on the board read the minutes from
Yeah.
the previous meeting. Do I have a motion to accept those minutes?
I'll make a motion to accept the minutes.
I have a second?
I second.
All in favor?
Aye.
Aye. Minutes have been accepted. New business, there is no new business this evening. We have an action on a decision from last month, the Kumar decision. This was a decision for an area variance to permit the construction of a new single-family dwelling on a lot having no frontage on a public street pursuant to Section 31012A2 of Village Code and 280A of Town Law. Building lots must have a minimum frontage of 100 feet. Said vacant property is located in the R2A zoning district on Campbell Avenue, private road, in Highland Mills, and is known on the Village of Woodbury tax maps as Section 216, Block 7, Lots 2, 3, 13, and 14. After several pages of findings, our decision is as follows. In employing the balancing tests set forth in the Village Law, Section 7-712B, C, the Board hereby grants the Village Law, Section 7-736 variance as requested upon the following conditions. 1, an unrecorded private roadway easement and maintenance agreement exists and is signed by those residing on Campbell Avenue. This variance approval requires that the applicant join in the mutual obligations of that agreement, preferably by recording an instrument setting forth the same obligations or different obligations satisfactory to all existing parties to the agreement. The recorded instruments shall be satisfactory to the zoning board attorney. Should the applicant fail to obtain an agreement from those others to sign a recordable instrument, in such case, written specification of the attempts made to obtain such agreement must be submitted. Then he must record a declaration running with the land, announcing an obligation on the part of the current owner and all future owners of the property to share the roadway maintenance obligations of the existing unrecorded private roadway easement and maintenance agreement. The instrument shall be satisfactory to the zoning board attorney. No building permit will be issued until this condition is satisfied. Number 2, a revised map showing the consolidation of the 4 lots must be filed with the Orange County Real Property Tax Service Agency, and no deed may be recorded until such map is filed. The map shall provide accurate dimensional and area data regarding the consolidated parcel. The applicant shall copy the zoning board and building inspector on its letter transmitting that map to the Orange County Real Property Tax Service Agency for filing, and shall provide both with any return correspondence reflecting either acceptance or rejection of said map. Number 3, the applicant shall copy the zoning board on its letter transmitting the deed to the Orange County clerk for recording, and shall provide the zoning board with any return correspondence reflecting either acceptance or rejection of said deed. Number 4, no building permit will be issued until proof of map filing and deed recording are received by the village. Zoning board approval of this lot consolidation shall not be deemed an acceptance by the village of any road or other land shown on said map. 5, this approval is not granted in a vacuum, but rather one of 2 independent yet interconnected discretionary approvals, the other being within the jurisdiction of the Village of Woodbury Building Department. As such, this grant of variance is conditioned upon approval of the proposed building permit by the Village of Woodbury Building Inspector. This approval by the Zoning Board of Appeals is intended to do no more than vary the specified strict limitation provisions in question. It is not intended to authorize construction of a particular building, nor approve the footprint, size, volume, or style thereof. The building inspector remains possessed of all his power and authority to review, limit, request modifications to, and to ultimately approve absolutely or conditionally any reference to this project as may come before him. Number 6, this application is not decided in a vacuum, but is rather, as noted above, tied to specific application for approval of a building permit pending before the office of the building inspector. Therefore, this approval is conditioned upon the applicant diligently pursuing his application before that official. This grant of variance, unless extended, shall expire if a building or occupancy permit for the use is not obtained by the applicant within 90 days from the date of the decision. We're going to take a vote. Joe, how do you vote?
I vote aye.
Thank you. Gary?
Vote
Gary?
to accept.
Kevin?
I vote no.
Andrew?
Nay.
I vote aye. So the decision is a favorable one for the applicant.
I'll send it back to you.
Okay, the next order of business is a public hearing. This is Kubitschek Markowitz, continuation of a public hearing. Last month, the applicant could not be present, nor could their lawyer. Continuation of a public hearing for use variance to permit the use of a single-family dwelling located in the senior housing section of the Woodbury Junction subdivision be occupied by family members under the age of 55, pursuant to Section 310-36C2A 1234 of the Village Code. No persons may occupy a senior housing unit under the age of 55 unless permitted pursuant to the above-listed sections of the code. Said property is located in the SH zoning district at 27 Southfield Falls in Central Valley, which has the mailing address 27 Southfield Falls, Monroe, New York, 10950, and is known on the Village of Woodbury tax maps as Section 255, Block 5, Lot 21. I'd just like to mention that we have, to enter into the record, we have numerous letters from residents, both in favor of and opposed to the applicant's request. We have documentation in support of the application from the applicant. We have email correspondence from our building inspector discussing the rules of the senior housing with the applicant. We have a copy of a restrictive covenant of the property along with an email dialogue opposing the noncompliance of the property, along with some other relevant documents. We have a letter from the HOA opposing the applicant's request, and I believe that's all we have. Did I leave anything out? Anybody notice anything that I left out?
I think it's all of it.
Thanks, Joe. All right. What we have here is a house that is zoned for senior housing. A couple purchased the house in June of 2017. Living in the house at this time is that couple, their son-in-law, daughter-in-law and son, and 6 children, which is against the zoning violation. They are under the age of 55, and the other problem is that senior housing can only have 4 people living in it. This is a use variance that the applicant is seeking. This is different from an area variance. Most variances that come before our board are area variances. And with a use variance, it's got a very high standard. And it has nothing to do with the town or village. It has to do with New York State. The New York State use variance requires that the applicant show unnecessary hardship. And there are 4 prongs that the applicant must meet, and each and every one of those must be met. If only 3 are met, the variance is not granted. The 4 prongs are: the land in question cannot, if the land in question cannot yield a reasonable return in dollars and cents if used for any use permitted in the zone. If the applicant can prove that, then that's one prong. The second prong is the use to be authorized by the variance will not alter the essential character of the locality. If that is proven, the applicant has a better chance of getting the use variance. Number 3, the hardship is unique to the parcel and not general throughout the zoning district. That must be proven. And the last one is that the hardship cannot be self-created. All four prongs must be satisfied. This is not something where the zoning board can go, oh, whatever. There's no wiggle room. If the four prongs are met, we must grant this variance. If the four prongs are not met, the variance is not granted. Is the applicant present?
Yes.
Thank you. Would you go to the podium and state your name, please? Thank you.
My name is Robert Rossborough. I'm here on behalf of the applicant. My name is Robert Rossborough. I'm here on behalf of the applicant. The board has our application. It addresses each of the four factors that you have outlined in the presentation, and I'm just going to run through them a little quickly so that the board and the public has an opportunity to understand what our application is seeking. As the chairperson identified, we're seeking a use variance from the senior housing restrictions in the zoning code. The home is owned by Ms. Markovitz, who is over the age of 55 and currently residing in the home, is her son and daughter-in-law and children. For the no reasonable return on investment prong, as the real estate data that we submitted in support of our application shows, there's virtually no, if any, market for over 55 restricted housing in the village of Woodbury. The buyers are largely families with young children or children at least under the age of 55. And the owners of the properties in the Woodbury Junction development are seeing stagnant value of their properties or a loss in value as the data that I supplied shows. While market prices generally in the area have increased by 14%. That's a significant difference when you're talking about what the senior housing restriction does to being able to recoup value on an investment. Here, there have been properties within the senior housing zoning district that have been listed for sale and sat on the market because there is no available buyer that would satisfy the zoning code's restrictions. It's also reflected in the statements of the residents that actually live there. This has been a significant issue, and because there's no market for the sale of these homes, there's no way my client could return an investment on their investment in the purchase of the house. This is also a unique hardship to this property and my client. The client's position, without a variance, they'd be basically left without alternative housing. They have, because of the way that they live and their family structure is, my client's son's wife is home with their children, taking care of them, and he works a small job that provides a meager income, but not sufficient income to afford different housing in the village of Woodbury or the surrounding areas, whether that's rental housing or purchase of a different home. The community character of the Woodbury Junction subdivision is a residential subdivision like you'd see anywhere else. It's, fairly decent sized lots with single family houses. Change in one of the, my understanding is 120 particular units in that subdivision have been approved for senior housing. A change in one isn't going to change the character of the entire community. There still would be ample senior housing for other individuals if there was a market for it. But like the real estate data shows, there just isn't at the time. Finally, this not self-created, this home is owned by someone who is over the age of 55. This isn't a self-created hardship because the ownership satisfies the criteria. What we're seeking a variance for is just occupancy of the home that would allow my client's family to continue to reside there while they don't have alternative housing and can't afford it. That's basically the summary of what our application seeks in this one particular instance. If the board has questions, I'd be happy to address those.
Do you mean they didn't know they were buying senior housing?
They didn't at the time, is my understanding.
Who was their attorney?
I'm not sure who advised them on the purchase, but it wasn't me.
That's good.
It's the opinion of our attorney, but even before he told us that, I have to agree with him after I read the planning and zoning document from the New York State Department of State, that the information that you offer, the details that you offer in terms of not being able to secure a reasonable return on investment is anecdotal and doesn't represent satisfactory proof to this or any other board. Meaning that you would need to provide expert testimony before this board. Mike, can you state it a little better than I have?
Well, the requirement is that dollars and cents proof be submitted. That generally does require expert testimony, but it certainly requires raw data. There is some provided, obviously, as to market values, and it was attached as Exhibit B or C. There's been nothing provided by way of what the costs are to maintain the home, carrying charges, maintenance, upkeep. Also, I think there is a confusing piece to me, and that is whose hardship is this, the owner's or the son and daughter-in-law? And if that is the focus of the hardship, which, number one, appears to be personal, not related to the land, I don't know that it's fleshed out with dollars and cents proof. And to the extent that there is raw data, I think what Gary is suggesting is in order for it to be meaningful, there'd be some expert opinion needed to analyze that data and put it in a position that made out the required dollars and cents proof. I think that's what Gary's getting at.
Michael, would that require also personal financial data as well?
Well,
If they're claiming a hardship?
yeah, as I mentioned to you in my memo, the hardship itself cannot be a personal one in nature. It has to be a hardship that is tied to the property. And that also ties into the uniqueness piece, and it seems to me some of the proof here suggests that there is a soft market overall, not just for this unit, but for all of the senior units, given the lack of willing buyers, that would purchase the units. I don't know how that hardship of the fact that the family may be homeless, which is personal in nature, relates to this one unit as distinct from all of the other units. I think there's some missing pieces that I think are why the board is raising the questions they are.
Certainly, and that's information that I can take back and discuss with my client and provide additional information if the board would request that.
It's my understanding that this is the second time that this family has been issued a violation. The first time they did leave, then they came back. Where did they go the first time?
I'm not aware of that right now, but I can confer with my client and provide the board with that answer.
Any board members have any other questions?
Karen, I'd
Sure.
just like to refer the gentleman to that document that's online. You can get it from the New York State Department of State. It was written originally in 2005, and it's been updated. And it's, in general, planning and zoning, details, requirements, descriptions, the whole 9 yards. It's a lengthy document. It's very valuable. And it lays out with great specificity the extent to which the bar has been raised for financial proof and what you have to do, and it even cites legal cases as to what you need to bring to this or any board to uphold your request.
Sure.
Any other questions from the board? All right, thank you, sir.
Thank you very much.
I'd like to open this up to the public. Is there anyone in the first row who has any comments? Would you please go to the podium and state your name? Thank you. And I'd like to remind the audience that when you speak, you address the board, and only the person who is speaking should be the one speaking, not anyone in the audience. Thank you.
Sure. My name is Kim Mead. I've lived here for 38 years. I wanted to address the board because in looking this over, I'm also an attorney and a former ZBA board member. It seems very clear that there's no way that they would meet the requirements for the use variance, so I don't really think it's worth the time to come back with additional information, so I thought I'd just speak up about that. The first one was the only aspect of it that I thought they had potential to maybe meet. And even with that, with the lack of value, considering that they bought the home in June of 2017, a few months ago, that kind of goes against that. I don't know how much the market has dropped in the past few months. The second one, the alleged hardship, I agree with your attorney. It's not specific to the property at all. It's a personal hardship of a renter, apparently. Another question on that, I was wondering whether the owner of the property is residing in the property. That was unclear. It sounded like perhaps the 55-year-old or over 55-year-old person does not reside there, so that might be something of an issue. The third aspect, I completely agree. The variance, if granted, will not alter the essential character of the neighborhood. It's a 55 and older neighborhood. This is a family with 6 children. That's completely against, the point of the neighborhood. And that the hardship was not self-created. I find it really hard to believe that anyone bought a house in that neighborhood not knowing that it was senior housing. So I think that that is probably not true. So that was my statement on that. I do feel for the people in the neighborhood that are having trouble selling their homes, and maybe this should be a consideration for rezoning the neighborhood. But I don't think a spot use variance for one home where all of the homes in the neighborhood have the same situation would be the appropriate avenue for that. Thank you.
Thank you.
Thank you.
Anyone else in the first row? Second row?
My name's Louise Gerwich, and I'm a resident in Woodbury Junction in the senior housing. My husband and I live in the 55 portion of Woodbury Junction. Our home is one of only 30 built starting over 7 years ago out of 130 designated lots for seniors. We know from personal experience that not just the value of our homes, but the very ability to sell, if we so desire, now depends entirely on families being allowed to move into this section. We've spoken to the Markovitzes on several occasions, and they're lovely people. That said, though, granting a single variance to their family does not address a critical underlying problem in the development. Since the sale of Woodbury Junction to George Kaufman 2 years ago, the market for homes designated as 55+ in Woodbury Junction, not elsewhere around the country, has virtually evaporated. Several months ago, we asked Mr. Kaufman, the Village Zoning Board, and our Assemblyman to resolve our crisis by working together to remove the age restriction. Mr. Kaufman has taken no action to submit a proposal to the village. He may prefer to wait many years, since several hundred all-age lots remain to be built. We also understand the village has concerns about environmental impact and studies needed to be done in order to build out the rest of the community with additional residents in mind. We think it's unfair and unnecessary for those of us that want or need to move to be held hostage because of this impasse. You can and should do something to help the couple dozen of us caught in a financial and personal limbo. The existence of hardship, which provides the basis for the Markovitz petition for a variance, applies equally to all the residents of the senior section of this community. Therefore, we're asking that you grant variances to all existing homes in the senior section so that those of us who need the freedom to sell to families, whether because of financial, health, family, or other reasons, can do so. Mr. Kaufman could later seek an arrangement with the village on how to proceed with the 100+ lots, 55+ lots, without holding us hostage. Granting variances to the existing 30 homes so that they may sell to families would have a negligible impact on infrastructure. A good number of current residents have absolutely no intention of moving in the near future, but the vast majority of senior residents are tired of living with the knowledge that should it become necessary to sell, their greatest asset has become their greatest liability. This has already come to pass for a few of our owners. A minority of seniors have expressed dismay about children living in the neighborhood. We think that complaint is in no way equivalent or comparable to the dilemma we face. It is in your power to give us back the value of our homes without losing your edge in negotiating with Mr. Kaufman about building the necessary infrastructure for the community to thrive. Thank you.
Is there anyone else in the second row?
Hi, my name is Patricia Siegel. I live in Woodbury Junction in the over 55 section. I first have been asked to read a statement from my neighbors, Helen and John Callanan, who are away at this time and could not attend this meeting. I will do so now. Helen and John Callanan live at 17 Stillman Y. She states, I am writing to you to beg you to provide a variance to all of the 31 remaining homes in the over 55 section of Woodbury Junction, not just to one home. Without this use variance issued to all the existing over 55 homes, we are in a dead-end situation because we no longer have a market for our homes. The social climate in Woodbury Junction has changed, and the senior citizens who purchased these homes in good faith are now without options to sell. The demand in this community is now for multi-generational homes, not for over 55 age-restricted homes. While our home was our greatest investment and our backup in case of financial difficulties, it is now worthless as a designated over 55 home. If we become ill, can we rely on selling our investments to help pay for medical care? No, we cannot. The current and future market here is for multi-gen homes only. If we die, can we leave our homes to our children to sell? No, we cannot. Again, multi-generational homes are the only selling point here. If a spouse passes and household income, Social Security, pensions, etc., are cut, we cannot afford to live here with the increasingly high taxes. And please note, we pay the full amount of taxes, the same as the multi-generational home. However, we do not have an option to sell to survive. Do we have a fair market value for our over 55 homes? No, we do not. We are kept prisoner here in a community that will never grow as an over 55 community. We are in a dead end. We have been deceived. We have heard 2 years of promises from current sponsors of the community and are done with the procrastination and unkept promises. Our only recourse is to appeal to you, our leaders, to stand up and help us. We purchased our homes in good faith, with honesty. We want to do the same when we sell our homes in good faith and honesty. Allowing a variance to one home is clearly a slap to the rest of us. Our survival depends on your vote for all 31 established homes to be set free. What you and Mr. Kaufman decide to do with the additional land designated for over 55 is a totally another issue. Right now, that is merely land that can be negotiated, not lives, depending upon your decision to help us survive. Those of us who wish to sell are stuck because of the over 55 restrictions. The situation which provides the basis for the individual petition for a variance applies equally to all of the residents of the senior section of this community. We are begging you to help us rather than sell us out. Please give all the remaining 31 homeowners the option to survive by granting us the use variance needed so we can sell if we have to. That's Mr. and Mrs. Callanan. I would like to add that when I purchased my home 8 years ago now, that's how long I've been living there. I mean, there was this vision of this wonderful lifestyle I was going to have. I was going to live with people that I would have much in common with, as well as there being a section with families with children so that there would be the children, there would be the lifestyle. To put these people out of their home, I think would be a disgrace. These are our fellow men. Is that how we treat them? My God, is that how we become? That's a shame if it is. I really would hate to see that happen. However, we have come to the town several times to ask for help in lifting the age restriction. Each time we ask, we're told the only way, you understand our plight, you're sympathetic with our plight. However, the only way that the age restriction can be lifted is if Mr. Kaufman, the sponsor, places a petition before you. As of today, he has not done so. You have an opportunity now, I believe, to help us, to give a variance to all 31 homes, and then negotiate with Mr. Coffin when he decides he wants to do something with the other 98.
I don't know if we have the authority
No,
to change
we
the
do not.
zoning.
We don't.
There's
We
only
don't
one
have the
application.
authority
It's
for
only
that.
one.
So we're dead, we're done.
Yeah, we can only
We can't change the
address,
zoning of the village. We
Right.
don't have the authority to do that.
we
So
can only,
Either the-
what do we do?
Trustees, the village board, or the attorney general who wrote this plan. The attorney general wrote the plan, you're gonna have to get him to change it. I'm sorry.
Contacted him as well, and everything is falling on deaf ears. So we all have a
Wait, excuse me.
$500 investment that means nothing.
Do
And
you
I'm
wanna-
sorry about that.
Well, that's what we hear, we're sorry about it, and
But-
we want to put a family out in the street.
Well, in addition,
I-
in addition.
okay, wait a minute, wait.
I'm done.
We'll, we won't. Is there anyone else in the second row who would like to speak? Third row?
Ellen Mahovics, 25 Staten Fairway in Woodbury Junction. I apologize for having to read this. I talk about this 24/7. I read about it 24/7, so I should more than be able to just speak about it. But into this setting, I would prefer to just read my comments. This variance request is really about so much more than whether 4 provisions are satisfied or albeit important, one particular family only. It would be short-sighted and lack comprehensiveness and justice for the family as well as all of us to not consider so many other things that preceded this and which continue to happen in Woodbury Junction in making a decision about this variance. We are imploring all powers that be to think outside the box as you absorb and process a very complex and troubling situation. I would be remiss and disingenuous if I did not start out by pointing out that this situation is partially rooted in the granting of continuous phase changes in a development which resulted in the 55-plus section today, consisting of merely 30 or so houses out of what was supposed to be 130 or 140 originally, I believe, and the resulting desperation of sellers. So when you consider whether this situation was self-created, which is one of those 4 points, it would be overly simplistic and not honest to not acknowledge that so much about this came about because of what was happening in this development. In the state of California, what we currently are in size, and have been for several years now, would not even qualify for a 55-plus development. We are that small. Now, I know we're not California, but just to get a big picture of this. While at the time it might have seemed empathetic and proactive to address the original builder's pleas of no market for his homes and frantic need to constantly change phases, it is quite ironic that comparably the town and village have to date responded with very little sympathy for our plight here, as we have faced owning homes that no one can buy, feeling imprisoned, and not having enough money to fund long-term care if we ever need to move to a different setting. While the impetus for change is on the developer or HOA, lacking any information on the future for 2 years now, we tried to address this problem early and have pleaded with no avail for some help. I just wanted to point out a few facts, some of which have been pointed out already. First, we face market conditions that have changed in an unforeseen way. Our 55-plus communities market belongs to a community with a culture not aligned with 1 or 2 people buying, over 55, buying homes of our size only for themselves. Unlike other market conditions, without help, this is an unrestrained market force that is not going to change. Second, as we all know, the senior exemption is part of the Fair Housing Law, which is part of the Civil Rights Law, and rooted most basically in freedom and liberty. It is hard to feel free when you are entrapped in a home for the later years of your life, when you may not want to be, when you may need to move to be close to children or grandchildren, when you may need to move because you have a sick relative, or fund your own care or the care of your spouse. Third, any brokers that have sold homes in Woodbury Junction will tell you they have loads of potential buyers willing to pay fair market value for our homes, but they are all families. So we face a situation that though we have beautiful new homes 50 miles outside of Manhattan, a mile from highways, we are left with homes we can't sell. Fourth, we currently have 6 houses unoccupied for the most part, in some part due to this restriction. Empty houses are havens for potential arson, misuse by teenagers and other people, and potentially harmful and even fatal results. Fifth, Unlike other 55-plus communities that have thrived, we unfortunately have not and have received no assurance of change in the future. We are merely a little over 24 homes that won't allow children. That's all we are. The offering plan, as compared to more progressive and successful 55-plus communities, was scarce for this section of the development because the original builder's heart was never in building a thriving 55-plus development. And in fairness to the people in multi-generational, the offering plan was never fulfilled anyway. So I don't want to act like the 55-plus was any more affected, but there was no, it just was not a 55, it was not an offering plan that really was robust for people 55-plus anyway. Toll Brothers builds great 55-plus communities because they are in it for the right reason. This community was forced upon this builder, and that has shown. Having houses possibly worth nothing or waiting years before a buyer comes is a really high price to pay simply for not having children living in houses nearby. Buying a home is never equated with a game of blackjack where you could lose it all. We understand the developer's role and the need for reconsideration of land use for future development of lots originally designated for 55-plus. But we are real people living in real time, and our lives passing us by now as we live in fear of zero-worth homes while we pay the same full taxes of everyone else in the community. My husband and I are of the opinion that you grant the Markowitzes a variance to prevent their hardship. Again, they can't sell this home. So I know you were talking about, and I understand you need proof of all of that, but, you can ask any broker. These homes cannot be sold. There is not really a market for people over 55. So that this will end up just being another empty house. And I guess, I apologize for saying something out of the audience, but I guess I find it amazing that, there's a problem. We've identified this problem. We've gone to everybody we can. We've been saying, this is going to be a problem, this is going to be a problem. And quite honestly, the only person, and unfortunately he's not even here anymore, is David Sutz, who at least had some sympathy and actually had some compassion and listened to us. I have tried to have a meeting with the mayor. He completely dodges this altogether. Quite honestly, I'm half joking and I'm half not, but the movie that's out, 3 Billboards, I don't know if I need to start putting up billboards on Route 32 in the town of Woodbury to get the attention of people, because we don't know what we can do. So what I am saying is to seriously consider some of the events at Woodbury Junction that have been allowed to fester for all these years that actually partially led to the Markowitzes occupying this home, and to consider an application for variance for those of us left in the community so that we have the freedom to sell our homes if and when we ever may need to. To continue to do nothing is the worst debasement of the spirit of the 55-plus fair housing law. I just would like to, for the record, in addition to my comments, I would like to just read the I will give you a copy of our HUD complaint, as well as the ID number, and read the question and answer, which is what prompted us to put in a complaint to HUD. This is for our kind of situation. Can an owner of a dwelling file a complaint based on familial status if the owner is being impeded in the ability to sell or rent the dwelling because the housing facility/community is claiming to be 55 and over housing, but does not meet the requirements for the exemption? I haven't really heard that come up yet, but we have reason to believe, and that's all been included in our paperwork to HUD, that this community does not satisfy. It satisfied it in terms of the initially and all of that. But you have to, just from a fair point of view and a common sense point of view, you don't just slap a 55-plus up and say, oh, you guys are 55-plus, and then never do any of the things to make it a thriving community, okay? There's been no marketing at all to 55-plus for several years now. There was a period of time that there was no HOA, so that's, so no one was really watching the shop. There have been people that have occupied the homes that have been in violation, and none of that was ever addressed before. And it was what it was. But, you kind of have to take all that into consideration. I mean, I understand what you're saying, but you have to also understand what we're saying. Where do we go with this? So we become a community that we have zombie houses, and would the village of Woodbury want this? I mean, I can't see anybody wanting that either. So I just wanted to submit that, as well as I have a 54-page article that I only have one copy, but I kind of would urge everyone to, if you have time to read this, it's just extremely informative about 55-plus developments in general, and it's highlighted certain things that kind of do apply to what is going on in our particular development. Thank you.
Thank you.
Should I give this in now, or? should I give this now?
But I think they're gonna have to start
You can-
limiting the amount of time that people are talking, they're gonna be up here all night.
This won't,
Do I submit this? Bring it in. Okay, that's it.
And I sympathize with them.
is there anyone else in the third row who would like to speak? Fourth row? Fifth row? Sixth, is that a sixth row back there, or is that just a? Is there anyone left who would, okay, thank you.
Good evening. My name is Joe Zlotta, and I too am a resident in the active adult section of Woodbury Junction, Central Valley. Let me start by saying this hearing is not meant as a referendum on the current state of the active adult community. It is a request by an individual homeowner for a variance that would allow the continued use of the property in question in a manner which is not currently zoned for. Having reviewed the applicant's petition, I am of the opinion that the applicant has not met the criteria necessary for the granting of such a variance. Contrary to the applicant's statement that they purchased this home without knowledge of the village's zoning regulations prohibiting occupancy by any person under the age of 55 is in itself an indication that they either did not do their due diligence or chose to ignore the results of the title search performed by Judicial Title Insurance Agency, which should have identified the deed restrictions that are clearly indicated on said deeds and which I provided to this board in writing, and is additionally clearly indicated in the Declaration of Covenants, Restrictions, Easements, Charges, and Liens filed with the Orange County Clerk's Office, as well as the association's bylaws. Claiming a lack of knowledge is not a reason to approve this variance. If this is their claim, they would be better served in civil court with an action filed against the title company, the realtor, their attorney, and potentially the seller for not disclosing this information. Applicants also claim they would suffer financial hardship should they have to sell. I would submit to you that this hardship is no worse than that faced by any other resident. In fact, this too is a situation of their own making. They chose to pay $420,000 for a home that sold for $370,000 in March of 2013, a $50,000 premium, and $11,500 over the original selling price on February 25th, 2011. I would also like to point out that applicant's attorney makes note in his petition that the average market price for a three-bedroom home outside of the senior housing district is approximately $236,000. Had the applicants purchased outside the development, they would not find themselves in their current predicament and would not be at the financial risk they claim to be at. If the goal was to secure housing within the development, a home of similar size and price and with twice the amount of land was available in the all-age section of the development within 6 weeks of the closing date of the applicant's home. Here again, this would be another indication that other options existed and that the situation the applicant finds themselves in is of their own making. Applicant also uses my own home to demonstrate the loss in value they may face. This does not come as a surprise to me. When I purchased my home in 2012, I did so with my eyes wide open, understanding the risks involved in buying into a developing community. I had no illusions that selling would be easy or when any potential buyer could choose to build their own home to their own specifications. I hold myself responsible and accountable for my decision. The applicant should do the same, especially considering they should have known the current state of the development. The purchase of real estate is an investment like any other. It carries risks with no guaranteed return on equity. The landscape is littered with examples of depreciating values caused by a host of issues. The supposed lack of market for senior housing may be one, but then again, I question that supposition based on the fact that the developer just broke ground on 2 new homes in the active adult community of Woodbury Junction. In their petition, applicants also claim that the issuance of this variance is welcomed by the community. While it may be true that some would welcome a change in zoning, it is not true of everyone. I am sure you have received a number of letters opposing this request, as well as a letter from the Board of Directors of Woodbury Junction Homeowners Association requesting that this application be denied. I personally know of a number of residents, some of whom are here tonight, and equal or greater in number than the residents who indicated support of the issuance of a variance in their emails to the client's attorney, who are adamantly opposed to the issue of this variance. If you approve this variance, you will be circumventing the association's rights to enforce the provisions of its bylaws. Your action would be contradictory to the terms of the offering plan filed with the Real Estate Finance Bureau of the New York State Attorney General's Office. It would be contradictory to the terms of the Declaration of Covenants, Restrictions, Easements, Deeds, and Changes filed with the County Clerk's Office. Additional challenges in selling surrounding parcels as active adult could also be created. And it would start this board and the village on a journey down a very slippery slope, which there will be no turning back from. The decision that you make must not be made on the impassioned pleas of others, nor the empathy that you may have for the situation of these applicants. It must be based on the law. I would submit that the criteria for granting such a variance has not been met, and that the applicants should not benefit from their negligence, and therefore the only ruling that is logical is for this application to be rejected. Thank you.
Thank you. Is there anyone who had a change of heart, would like to say something? Whoa, 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 whoa.
Who the hell do you think you are? She didn't say anything to you. You don't tell her, screw her. Watch your mouth. Take that like Drake, your little fucking ass out there. You see what he said to my wife, you asshole?
Sir, sir.
I would just like to state that I find it very interesting that Mr. Zlotta opposes these people living in this home when he had his own family living in his daughter, son-in-law, and grandson. There was never an issue. We never had a problem with that. We never had a problem when there was another under 55 age couple living in the home. We never had a problem when there were renters with children living in homes, and the school bus would stop on the road and pick up these children. It was not a problem. And I'm going to say something that you're really not going to like. I think if their name was Murphy instead of Markowitz, we wouldn't be here tonight.
Nice.
Anyone else have something to say?
I wasn't going there. But I'd also like to address the fact that the
Could you please state your name?
I'm sorry. Kathy Zlotta. I live at 41 Staten in Woodbury Junction. The fact that the couple that you were talking about is my daughter, my son-in-law, were also living at our house. They stayed with us for a period of time shortly after the birth of their son while they searched for a home. It should be noted that we continued to occupy the home. We weren't here without two seniors, they weren't here without two seniors residing in the home, and it was on a temporary basis. At no time did Mrs. Gerwich or any other resident raise an objection or file a complaint. Had they, we would have moved my daughter's family into our home on Long Island, which we still maintain, and my son lives. I find it incredulous that this is pointed out, yet no mention is made that the Mahovics had both their son and daughter staying with them for periods of time, or that Mrs. Ashkenazi has had her granddaughter staying with her for prolonged periods, both of whom have written in support of this variance.
I would,
Hey,
hold on.
But we haven't.
Could I stop you for just a moment,
Yeah.
please? Is there anyone who has something to say in relation to the use variance and not about neighbors?
Yeah. We don't
Please.
care about
We
the
don't want,
neighbors.
no,
All right.
we don't want to really hear about who had who living where. We need to hear
Okay, having said that.
your
the
views on the
association-
use variance.
Okay, the association's bylaws do not limit the period of time a resident may have a temporary guest or guests staying with them. This is a completely different situation than that of the applicants, where no one age 55 or older is currently residing at the home and where the living arrangements are anything but temporary. So when my daughter and son-in-law and their newborn were staying while they actively looked for a home outside in wherever they were looking, it was temporary. It was not on it was only, I don't know how many months they were there, but it was under 9 months. It was about 9 months after the baby was born. And then they moved out. And we had told them too, on no uncertain terms, that when they did come in, that if somebody had said something, at that time, we didn't have any homeowners association that was taking any kind of active interest in what was going on. If somebody or one of my neighbors had mentioned that there was a problem, that they could not stay there, we told them that they would have to move out, that they couldn't stay with us while they were, while she was recouping. But this has just gotten very ugly. I don't like standing up here and talking to my neighbors, but this is just ridiculous. So,
Thank you.
I'm done.
Is there anyone else who has anything to say?
Can I just throw one thing in?
No, not right now, because we have someone coming up.
Good evening. My name is Peggy Nicolopoulos. I'm a resident in the multi-gen section of Woodbury Junction. I'm also an HOA board member, and I'm here speaking on behalf of myself. There was a lot of points made tonight. Yeah, in the past, there was no HOA. So what happened in the past happened in the past. Now there is an HOA board. Now we do have a developer who is willing to develop out this community, which I think is a positive. Now, it's not going as quickly as we would like it to. I understand that in the active adult section, there hasn't been any development until recently. They're starting to. It's a process. There's 450 homes to be built. So far, we got like about, 130 homes built already? Something to that nature. It's a process and it takes time, and we understand that. We're trying to do our best to accommodate the residents and try to put some law and order. And we were working together, and that's the step in the right direction. At least that's what I feel. But let it be noted that all these complaints have gone to other entities such as the town, such as the zoning board, planning board, HUD, wherever it went, they went to. But they didn't directly come to the HOA board. And everyone has access. Everyone knows who I am. They know who the vice president is. They know who the president is, our secretary and treasurer. They have email addresses. They didn't personally file any complaints with us so that we can properly direct these initiatives and take them to the proper channels and help them. They're not working together. We need to work together. We are very divided in this issue, and while I'm very sympathetic to the Markowitzes, and I understand their plight, but when we make our decisions, we should be going into these transactions with, it's our responsibility to know what the conditions are, what the restrictions are. It's up to your attorney, a real estate agent. Maybe those are the places of recourse where they can go and find, their recourse on this. I mean, it's unfortunate, and it's very unfortunate what's happening. It's very hard for us, because I plan on staying here to the day I die. I don't have a problem with it. I do have a problem with people that put words in other people's mouths. So like I said, I plan on staying. That's why I'm on the board, because I actually care about this community, and I don't care who lives next door to me. What I care about is that we all have to follow rules. And since now we do have an HOA, we're trying to follow the rules. Before it was, oh, we don't have an HOA, we need somebody, we need rules. Well, now we're trying to follow these rules. We're trying to enforce them. We're trying to get help from the town. We're trying. But this bickering and this back and forth it's just not, it's not helping anyone. And as far as for, with, like I said, they should have known going into this that this was a senior housing development. It's not fair to say, well, grant a variance for the 10 people that want to sell, how many people want to sell, and the rest, well, we'll figure it out later. It's up to the developer. If the developer wishes to change this and convert this to multi-gen, it's up to them. It's not even up to the HOA. What's up to the HOA is that we enforce the bylaws, and that's what we're here to do. And we are seeking the proper channels by invoking the ZBA to follow the rules as far as the area variance. There is a market I see for active adult housing in Wildflowers in Middletown, completely sold out. Warwick Grove in Warwick, it's sold out. What is the problem? The problem is the marketing and advertising and the lack thereof it. So who does that fall on? Maybe it falls onto the developers and their sales agents or their marketing agents. That's who it falls on. But there is a market for it. And if properly advertised and marketed, these houses will sell. The place is going to get developed. It's just taking long. But you can't expect to sell a home in a place that's undeveloped. So, I mean, I understand time is of the essence. But it's really difficult to sit here and say, well, there isn't, and we should just, screw over our rest of our other residents because a few feel that they want to leave, or not that they actually need to leave. I mean, if you're trying to sell your home in a market that's, that in a place that's not, you're not gonna, it's gonna take a while.
How many years is okay?
No,
Well, then you
please.
can't.
Please,
Come on, let's keep it
no.
quiet.
No.
No comments from the gallery, peanut gallery, please.
Thank you.
Thank you.
So, I mean, it's, we're trying our best, and I understand emotions are running rapid, but we are trying. We may not be the most effective HOA board, we are maybe not the most communicative, but we try to. And I wish they would have, people who had issues, they should have came to us, because now there is a board, and now we are trying to do things the right way. If they choose not to, or they don't want to talk to me, or they don't want to talk to someone else because our positions, hey, listen, that's on you. I'm trying to do my job, so is everyone else. We got to work together. Doesn't matter. We just all have to work together. And according to our bylaws, according to what's in our documents, it's a 55-plus community. There are two exceptions, and the exceptions are if the resident has a financial need or a medical reason that they need to have their children reside with them, people who are not 55 and under. Those are the two exceptions. And they have we have other lots in the community that they can buy a home in a multi-gen, that they can live in. There are options. Unfortunately, yes, there is a financial hardship, but these are the things that happen when you purchase without knowledge. And that's what the HOA board is trying to do. These are our bylaws. We can't change them. And this is an approved plan by the AG. It's an offering plan from the AG. We have reached out to the AG too. I have reached out to the AG. It's not easy, and it's something that we have to, they tell us you gotta wait, there's other cases that have more priority. I mean, these are the roadblocks to this. It's not an easy thing. And we're not sympathetic. It's awful. It's awful to have to be in this position. I've been here 3 years, and yes, there wasn't a lot of development until recently. And yes, there is more development in the multi-gen. But hopefully it'll change around for the active adults. And, I know time is of the essence, but I'm hoping the time will prevail. The new developers, they've heard everything. I know I speak very loudly for both sides of the spectrum, whether you believe it or not, but I do. And it's up to him it's his development, and he's going to do what he's going to do. And, it's just... But, respectfully, I would have to say that this variance must be denied according to the bylaws of the HOA and according to the offering plan.
Thank you.
Thank you for your time.
Thank you.
Yes, sir.
Hi, I'm Noel Gerwich, also having lived in the 55 and over section for a while. I know you're getting tired of hearing things that are, in your opinion, kind of off the mark of whether this specific variance should be approved or not. But we're trying to give a larger context here, and the idea of having variances granted to a whole group of people to resolve an intractable problem. I feel like you at least should be aware of it in case we follow up on this in other regards or in other angles. A lot of what Peggy said is frankly just disingenuous, and she knows it. Some of the things she says, I think she sincerely believes. But the idea that, we could have known that a developer would buy this property in such a way that the only buyers for the 55 and over community are the people with families. That we would know that is totally absurd. 55 and over communities are flourishing everywhere except in this one specific spot. So we're hoping that people in the future could think out of the box and perhaps help us as public servants. They're your public servants. You do a difficult job, maybe a thankless job, but we need help. And when Peggy's saying, well, things just are the way they are, well, things are crap, so why not just leave them that way? You can't do anything about it. We beg to differ. We have a unique problem that could not be foreseen. Peggy lives in the all-age section. She can sell her house at any time she wishes to because the demand is there. No one could possibly have foreseen the complete lack of demand. Yes, it is possible every once in a while that a house may sell, but many, many years could go by with a house not selling. It's a fairly unique situation, and that's why we thought of the idea of a group variance of some kind. Now, what I'm hearing from you is that you have limited powers to deal with variance, but when you have a group of people who are stuck, completely stuck, if you were in our situation, if Peggy was in our situation, she wouldn't feel this way. And so what we're hoping is that you are open to the idea of some form of a group variance, or that you might think of other ideas that you're aware of to help us in our situation, because frankly, we're fairly desperate. And those who are not desperate, frankly, don't give a damn, even though they pretend they do. And some others who disagree with us in our development have their own reasons for thinking the way they do, but ultimately no one gives a damn about the people with an intractable problem. And I just am laying this out there to say that we're sympathetic with the variance because we like to acknowledge reality and not necessarily the fact that every little law has to be adhered to strictly all the time. We understand that certain things are legal and not legal, but we're looking for a more sympathetic, helpful, out-of-the-box type of mentality in the future.
Thank you.
Thank you.
Okay, that's it.
Okay. Yes, sir.
Yeah, my name is Marvin Reiber. I bought a house in the 55 plus at 27 Stanton. I would like my intention was long-term for retirement. I should live there, but as of now, my intention was to be able to rent that out till I retire. I spoke to many, many brokers. I tried myself to rent this house. There was not one customer that would come up. I would rent it for $1,000 a month. I put in so much money in there. There is no customer that would be, if you can visit my house, I put in so much money in there. It's beautiful. You don't have to put in a dime. There are no customers willing to rent that house because it is 55. There are no customers for that. And that is a fact.
You own the house?
Yes.
You live there?
Yes, shortly, yes.
You're not
It's a
living there
second, I bought it as a retirement, but it's a second
You're
home.
not living there then?
No, I am 55.
Now, you got family living there, or are you renting it?
I can't rent it. I'm trying to rent it. Nobody wants to rent
Is this the
it.
same house we're talking about?
No.
Okay, then that's not germane to the subject.
Get me a
27
customer, I'll rent
South
it the next minute. There are no customers. You can take a look, drive up to that building, and see how much money I put in there as an investment with the purpose that I should be able to rent it till I retire, to move in. I can't rent it. The mortgages is high, the taxes are high, the house is empty, I live in New York City. It doesn't make sense.
Thank you very much.
You're welcome.
Okay, is there anybody on the board who feels the need to keep the public hearing open after hearing all the public comments?
No, I don't see no reason to keep it open.
Motion to close the public hearing.
Second it.
All in favor?
Aye.
Aye. Okay, public hearing is closed. We'll have a discussion at the end of this meeting. We have no building inspector's report. I don't believe we do. So now we will deliberate on the public hearing that was just closed. Okay.
Your paper?
Okay.
There you go.
So, what we have here is we have a situation where we have people from both sides of the fence, people against, people for. We cannot grant a variance to 31 homes. We can only entertain the variance request that is before us.
And this one's really restrictive.
A use variance is very restrictive. It's got such a high standard that it's very. Let's look at the four prongs and see if they've been met. The first one, the land in question cannot yield a reasonable return in dollars and cents if used for any use permitted in the zone. We don't have any realtor's appraisal of the property showing that the market value is substantially less than the $420,000 that was invested. There's no competent financial evidence of a hardship. The law says that actual, dollars and cents must be shown for each allowed use. What are your thoughts on that? Anybody have anything different? No?
It's pretty cut and dry what you just said.
It really is.
Yeah.
All right, number two.
It is the responsibility of the applicant and his
Yes.
attorney to have understood the specifics of that. Court
Correct.
cases in the past that that reference that and have supplied, along with their petition, have supplied this board with
Correct,
documentation, which
Yes.
we don't have.
correct.
And we've had use variances in front of us before, whether it was Yesterday's Village or Pulver, where they provided all that financial information.
And a Zillow does not represent, a Zillow
No,
poll
we
does not
need it-
represent
no,
that
no.
information.
Why not?
Okay, number two, the use to be authorized by the variance will not alter the essential character of the locality.
Relates to the property as being unique, Karen.
I'm sorry, did I?
No particular.
Order, yeah, I guess I was just doing, you want to do the uniqueness first?
I just,
Okay,
that's
we could
the
do.
way it's laid out.
Do what you wish.
Oh, boy.
Do you
All
want
right.
to do the other one, if that's the way you have it laid out?
All right, yeah, well, no, I was just reading off the state thing. The use will not alter the essential character of the locality. It's a 55 and older location. I mean, people bought in there for the purpose of being 55 and older. The
And I do
letters that we
sympathize
got.
with them.
Oh,
but
absolutely.
The law is the law.
I do. I feel bad.
Next time
I
you pull me
understand
over for
exactly
driving, I'm
what's
gonna say,
going on, but, you know,
The law's the law.
it's, all right, number three, the hardship is unique to the parcel and not general throughout the zoning district. Did you have something on the uniqueness, Joe, that you wanted to say?
Only in that, from what everybody was saying tonight, or a substantial amount of the people that spoke seemed to be in the same thing.
Right,
So
it's
it is
it's
not a
it's
unique
not a
thing.
singular, right. you're right. It doesn't seem to be singular. It seems to be more general neighborhood. Anyone else have anything on the uniqueness? The hardship is not self-created.
But it is
It is, and the law, case law backs this up 100%. It's not the ZBA's role to guarantee the investment of any careless or unknowledgeable land buyer. You're supposed to know, and if you don't know, that's, the law says, you know.
Caveat emptor, buyer beware, I mean, whatever you.
Yeah.
The law is specific as to the potential buyer or buyer is under obligation to find out all the information that is pertinent. It does come up on the original deed that it was a senior citizen house, that it is restricted as to who can live there and how many can live there and so forth. I don't know how the title search went. I'm not privy to that information, but they generally do a lot of work as far as checking into such things. And basically, the way the law is written, the due diligence falls on the potential buyer or buyer.
In that regard, I'd point out in the building inspector's file that you have before you tonight,
Right, that's what I
in
was-
May of 2017, before the purchase, as part of the request for a violation search from the building department, a request was made as to whether there were any limitations on occupancy. The building inspector sent an email to Simi Werner, who is a paralegal at Benzion Frankel, the firm that represented Kubitschek in the purchase, and he reported to that office that, and I quote, pursuant to Village of Woodbury Code, no one under the age of 55 may reside in or be listed as co-owner of a house in the senior citizen, open parentheses, age restricted, close parentheses, housing area of the Woodbury Junction subdivision, end quote. While this isn't direct proof that that information was imparted to Markovitz or Kubitschek, it is proof that that information was given to their attorneys as part of the due diligence process leading up to the day of closing.
Yeah, we got that. That's in your mailbox today, yeah. Anybody have anything else to say on any of the 4 points?
Unfortunately, I don't think we can help the.
It
the
doesn't
applicant.
look like any of the 4 prongs have been met. So, do I have a motion to write an unfavorable?
Karen, I think it's, given the emotion that's going on, the fact that everybody sitting up here, there but by the grace of God go I, and we certainly understand the misery associated with this housing complex.
It is. It's-
The criteria for granting a variance, especially a use variance, is clear, and our hands are tied in that even if we chose to grant a mercy variance, which we're not allowed to, but even if we did, it would not stand up to an Article 78. So I think it's important that the residents who've come here, I've seen tears shed here, I've seen tears shed at the planning board meeting, because the residents are looking at us as their last opportunity, so to speak.
No, I don't
It's
realize that.
heartbreaking.
I
But-
don't either.
But no.
The public
no,
hearing's
no, no,
closed. We
no,
cannot
no,
take any
no.
more comments. I'm
It's-
sorry.
It's a one-way conversation, I'm telling you.
We're just-
That
yeah,
that it is
we-
heartbreaking, but that we are bound and constrained by the law.
No, because, I'm sorry.
After the meeting now.
Did anyone make a motion?
Yeah, do I have a motion to?
I'll make a motion that we deny, we write a denial.
I thought you were going to make
No.
a.
I think we
motion
should,
you wanna
I think we should have a denial written.
And I'll second that.
All right. Okay, so Mike, you want to
We got
make
a vote.
I can
We
prepare
got a
the
motion.
decision, but if that's the
Right.
motion in
Karen.
a second, it has to go to a vote.
Karen, you want to discuss that?
Do we have to, is that,
If a
that's
motion
an
and a
inform?
second is made, it needs to be considered.
So that's not a formal vote, though, is it?
I think you're asking for a formal vote of
No,
disapproval.
I was gonna change it to,
Okay.
I recommend we write a negative
Prepare a decision.
decision.
For your
Negative
consideration
On their
at the next meeting.
application.
You want
Okay.
to rescind the first motion then, and?
Yeah.
Yeah, I guess
And I'll
then we
rescind
would
that
rescind that,
second.
so we,
Got that, Jess?
that we made in the
Okay.
attorney-client. All right.
I'm only
So-
recommending.
So the motion is direct preparation of a decision outlining the deliberations just held for consideration and vote at the next meeting.
So at the next meeting, we will vote on the decision. All right.
You still have to make another motion, though, right, in second?
Yes,
To
For?
Well, I think clarifying the motion that was made, if the mover agrees with it, and it can be reseconded, then it can be voted upon. I don't mean to step on.
Kevin,
So are we-
you gotta still do the.
I tried to.
He said he didn't want us to make a
No, to
motion.
direct preparation of a
To
decision.
the preparation of the,
I recommended.
Yes.
Right.
Are you gonna make a motion?
I clarified your motion, and I think you agreed with it, but it's your motion, so.
Yes, it's,
So your motion is to direct preparation of a decision that
Of a-
that
of a
that
negative
incorporates your
decision.
deliberations of this evening for vote at the next meeting.
correct.
And there's a second to that?
I'll second it.
Okay. So do
All
we
those
need
in
to,
favor?
do we have to say all in favor?
Yeah.
Yes.
Okay, all in favor?
Joe, how do you vote?
I vote aye.
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 Motion for adjournment?
Do I have a motion for adjournment?
Motion.
I'll make that second.
You make that second?
Yes.
Who made it first, Joe?
Yeah.
Uh,
Kevin.
yeah.
Okay, all right. Meeting is adjourned. Thank you so much for coming.